Hi, my name is Jackie Gutierrez. I'm with the California Restaurant Association, and this is Ask CRA on the Confidential Bulletin. Thank you for joining us. Today, I'm joined by Bruno Katz and John Guarino at Wilson Elser. They'll be sharing key compliance considerations and practical tips for preventing and addressing harassment and discrimination in the workplace. I will now turn it over to Bruno.
Hi, welcome to Ask CRA. John and I are happy to be here. So, what we're going to talk about here in our short little time is just some overviews of probably the thing that costs the restaurants the most money in the grand scheme of things is legal claims. That's where restaurants lose money, where they're distracted from doing their mission, which is taking care of the customers, serving great food, and having a wonderful ambiance. And so most claims come from how the claims are handled and understanding discrimination, harassment, and retaliation if you don't handle it right is important. So we're going to try to give you a quick overview. But one of the things that is really important is if you have one of these claims or there's a concern about a claim, it's not just about talking about and handling it, it's about documenting it. We see all the time in our work that, oh, yeah, well, he raised this issue and I dealt with it, but you have no records. So they're going to say, if you don't have records, if you don't have documents, it didn't happen. So, John, you want to give us just a little quick background about basics about harassment and discrimination and things like that?
Absolutely. I just do want to say when we talk about documentation, real quick, just as the old criminal attorney, what I always think about is, it's not just documenting what you do, but also making sure that you're documenting, the text messages that go back and forth. If there's a video of the event, making sure we have that, because a lot of times by the time the legal issue arises, those things have gone. They've disappeared into the atmosphere. Videos have deleted, and then you've missed out on some great evidence. But um, talking about harassment itself, I think most harassment claims in restaurants don't necessarily start with something that's obviously illegal. I think they start with behavior that management may think is normal. I mean, I know from my time waiting tables and working in restaurants throughout college and law school, there's a lot of yelling, cursing, public criticism, a little bit of harshness, ignoring people when they complain about certain things. Over time, this can turn into a claim, not necessarily just because of one bad moment, because of a pattern. But with harassment, there are protected categories, right? There are some issues that are protected, things that are like uh, race, gender, even military status. There's a large number of them. So, Bruno, why don't you talk a little bit about the protected categories?
So we live in California. Federal has a fair amount of protected categories, but you should be aware that there are so many protected categories in the state of California. And while this may be boring, it's important to know age. Technically, you can have age discrimination if you have an employee who's over 40. Seems unreasonable, but because over 40 are highly productive employees. I'm over 40, John's over 40. Ancestry, where you come from, the color of your skin, your creed, your gender, not just male, female, but how you express your gender, how you identify yourself, your genetic information. That's a protected category. Whether you're married or not, marital status, single, divorced, married. A medical condition is a protected category. A mental disability is a protected category. As John indicated, military and veteran status is protected. Where you come from, your national origin, if you have a particular physical disability, and race. And race doesn't just come from the race, it also can come from historically associated things with race, such as your hair texture, your type of protective hairstyles. This can include braids, locks, twists, your religion, sex, of course, pregnancy, childbirth, breastfeeding, other medical conditions related to sex, and your sexual orientation. So, this is a very vast protected category area that are given heightened scrutiny in the state of California, and you should be aware of that as a leader. What makes this sometimes interesting is that restaurants they're very diverse areas in a lot of ways. It's amazing to me that you have people of all different cultures, creeds, nationalities, and religions, and they all work together because that's what makes a great restaurant. And restaurants tend to be more informal. So you've got to be aware that while it may be informal, you still should be aware that you've got to be conscious that there are people that have issues and they are from certain different races, colors, creeds, national origins, sexual identity, gender, and et cetera, et cetera. And you've got to understand that while it may be more informal and you're taking things, you still have to respect people from other races. And usually restaurateurs and hospitality are actually very good at it. John, could you give us a sense of what might be some behaviors that could create a higher risk of
Yeah,
discrimination and what that might be?
absolutely. So some of the things that we see obviously are comments, and these comments can be jokes, can be things that are meant lighthearted, but comments that go to any of those protected categories could be considered harassment. The important thing to remember with this is we're responsible not only for our own employees, and our supervisors we're strictly responsible for. So even if we don't know about it and it happens one time, if a supervisor does some harassing conduct, the company is responsible for that. For other employees, we're responsible if we know about it or have reason to know about it and we fail to take action. But we could also be responsible for the conduct of our customers. So the comments that come not only internally but externally can be a problem. Some of the other issues that we've seen that have caused harassment or discrimination claims based on these protected categories have been a reduction in shifts, disparate treatment. So all of the people who are of this one ancestry, this one country, they get the good shifts, and then everybody else gets the bad shifts, or gets the shifts that are less favorable. Those kind of things can be an issue there too for harassment.
And when you talk about harassment, from a legal standpoint, what we look at is it severe and pervasive? Is it unreasonably offensive? Is it unwelcome behavior based on a protected category? And you, as the employer and the managers and the leaders, you've got an affirmative duty to protect and promptly correct those information. And you've got a duty to train. And everyone knows this is that every 2 years, you as managers, you have 2 years of 2 hours of training required, and for every line employee, they have 1 hour of training. So you need to make sure you have a log, you document your training, and you make sure you get the training done because that is going to be an issue if you go. I didn't do the training required under California. It's very important you get those, and so from that other standpoint, John, can you talk to us a little bit about common mistakes that people have when they're dealing with these harassment and discrimination claims from a leadership management standpoint?
Absolutely. I'm glad you talked about severe and pervasive because sometimes as the lawyers, we know the law and we know where we like to fight when we get a claim that comes in. But as the employer, as the restaurant, as the business that doesn't want to have to deal with these claims at all, you shouldn't be thinking about what's my defense going to be if I get the claim. You should be thinking, how do I prevent this from even happening? So that goes back to the first point. If there's cursing, there's yelling, there's harsh behavior, even if it's not aimed at one of those numerous protected categories, that's still conduct that you want to stop. Even if the conduct is a single comment, it's not severe and pervasive, it doesn't happen all the time. You don't want to say, well, it's not severe and pervasive, so I don't need to address it. What you want to be thinking about and to avoid the common pitfalls is when you see this conduct, when you see the things that gets close to this conduct, you document it and you take remedial action. So that doesn't mean you have to give somebody a write up. It doesn't mean you have to even give them anything them in writing. You can document it in a memo to file. So and so made this complaint. We talked to the person that said it. We gave them a verbal, discussion that it shouldn't happen again, and you've got that. It doesn't have to be every single time an actual write up. It just needs to be documented. If the complaint comes in a text message, make sure you're keeping that stuff. And a big one that we see, you may have done it right, and you may have done everything, you may have documented, but you failed to follow up with the person making the complaint or the person that was the victim, to use I guess a word there. Make sure you follow up, you let them know, "Hey, we took care of this, we addressed it, we spoke with so and so, please feel free to continue, to come to us." Making sure that you are always being open and available to your people to make complaints, regardless of how you may feel about how many times they've made complaints and the validity of their complaints, is very important. If it ever comes across that you're dismissive of a complaint, that you don't take action on it, or that you're not open to receiving future complaints, that can be a very, very bad factor against you in a demand letter or litigation.
And one of the other things to follow up on that, because everyone goes, what the heck does severe and pervasive means? It generally means it's interfering with the work performance. It's creating an intimidating, hostile and work environment. It doesn't mean that you're giving performance guidance or reviews to someone. It doesn't mean that you're telling them how to do their job better. It doesn't mean that our expectation is you arrive at a certain time, that you clock out for your lunch at a certain time, that you make sure you clean up and communicate with an employees in a certain way. That is not harassment, but people sometimes talk about that. So job performance related discussions is not harassment. What could be harassment are a bunch of things, such as the easiest one is an unwelcome sexual advance where you're touching. And harassment can be verbal, it can be visual, and it can be, any way, and it can be physical. Name calling, demeaning name calling. I mean, the old school way was, hey, honey, hey, sweetie, hey, toots. But that's not what we hear anymore. I mean, we're not construction workers, but we hear other people calling name calling. Um, showing offensive videos that are of sexual nature or of other nature that might be demeaning to a certain protected class. Insults and put downs, depending on what they say, could be unwelcome behavior. Physical threats, of course, comments on appearance. And, can you say someone, hey, I like your haircut? That shouldn't be offensive. But if someone finds it offensive, it's a reasonable person standard, and they say, please don't talk about my appearance, then you better stop from that standpoint. You want to look at this based on facts, and there is no one size fits all. From that standpoint, John, can you kind of tell us about, what liability looks like and what it looks like if you're facing one of these harassment and discrimination claims?
Yeah, absolutely. And most of the time, what we see in these, or we see a demand letter. You receive a letter from a lawyer that's representing either your typically your former employee, but occasionally your current employee, and they lay out all of the harassment that they feel they've experienced, and they make some ridiculous six-figure demand. Even when you have good facts, if you don't have that documentation, these can be in the thousands and sometimes even tens of thousands of dollars to have to make these things go away to avoid litigation. And I mentioned there in that previous answer, talking about current employees, sometimes we do see lawsuits or demand letters that come from current employees, but typically you'll see just a complaint with inside when they bring the complaint to you of harassment, and this is where folks can get in trouble with retaliation. Bruno, can you talk a little bit about retaliation and how that applies after complaints are made, whether it's an internal one or a formal one that comes from lawyers outside?
No, absolutely. So retaliation is, links a lot of times with these harassment and discrimination claims. And what is retaliation? Retaliation is where you take an adverse action. And what that means is a negative action against an employee because they've engaged in some kind of protected activity. And the protective activity would be complaining of saying you're being harassed or complaining that you feel like you're being discriminated. California law is really clear under the Fair Employment and Housing Act that there's got to be a causal link. There's got to be a link between the employee's protective activity and the adverse employment action. And what is an adverse employment action? It can be a lot of things. It could be reduction of your schedule. That could be an adverse employment action. It could be they've made a complaint and all of a sudden you've written them up about performance issues. And proximity and time is important in dealing with this. What is a complaint? What is it? It can be a demotion. It could be discipline of any nature. But what's not an adverse employment action? And the easy one is if you are having business reasons and you've already made a decision and you better have documented it, you're laying somebody off. You're having to lay off a whole division. That's not an adverse employment action. You're disciplining because they didn't do their work in a proper manner. But if they make a complaint, and it's not just whether the complaint is valid or not, it's whether they perceive it's valid. They can even make a complaint and say, I may have, you look at it and you go, well, you're wrong about the law and you're wrong about the issue. But all of a sudden they've made a complaint saying harassment and discrimination. All of a sudden their hours are cut, or all of a sudden they're written up for performance issues. So the proximity, the closeness is important. And retaliations are very difficult to get rid of because the presumption in the state of California and passage recently is that if you complain about discrimination or harassment, and then all of a sudden an action that is negative to their employment is done, they're going to assume you have a presumption to overcome as an employer that you took a legitimate business reason based on legitimate documentation to do that. And so that's why, when you deal with a protected activity, it's important that you document and you investigate the issue. You can't just, and when I mean investigate, I mean interview people if necessary, document, take things down. And so, in that respect, it's important to do so. John, from your standpoint, how do you think is a good way to manage, these retaliation and trying to figure out protected versus not protected?
I think what you need to do is you need to ask yourself, and I think 90 days is that's what the law is, right, Bruno? There's a presumption within 90 days if they make that complaint. So a lot of times what we see is the employee knows something bad's happening. They know they're about to get counseled. They know they're about to get fired, and they sense it. They know it's coming, and then they'll make one of these protected complaints to go ahead and try to shield themselves because they know they're smart. They know the law. They figured this stuff out. Savvy, at least I should say. So again, we're going to we're going to beat the drum on documentation. If you've got these independent reasons for wanting to do the action, right? You certainly the person was probably a problem in the past. They were late, they were tardy, they were calling out, no show, no call, no show. You got to make sure you're documenting performance issues as well. Right. So it's not just about documenting how you address complaints about harassment, complaints about discrimination. It's also about documenting performance so that if you want to make a decision, whether it be discipline, whether it be suspension, reduction in schedules, or termination later on, and they try to kind of block it with a discrimination harassment claim, you have the documentation going back in time about the performance to justify your independent, legitimate business reasons. So, documentation is one thing you should take away from this. You really, if it didn't, for us, for our side, if it's not written down, if it's not documented, it didn't happen. For their side, they can claim whatever they want, and we, almost sometimes feels like we have to disprove it, even though that's not what the law says.
Let me ask this question, John. We talk about employees or former employees. Does harassment and retaliation and discrimination apply to anybody else?
Yes, I mentioned just a little bit earlier, it definitely applies to your customers. And you just watch YouTube, watch reels. I don't know, depending on the age of your kids, whatever they're watching these days. Just watch social media, and you'll see the Karens and the Kens that are out there. I have a poor cousin named Karen. I feel terrible every time I use that phrase. But you watch those, and people are abusive. Sometimes people are abusive because just society has gone that way. Sometimes they're abusive, maybe they want to make a social media content. But our employees, your employees, are being subject to this stuff. And if you see these kind of situations, or you have reason to know that these kind of situations are happening, and you don't take corrective and preventative action, you can be responsible for that individual, for the customer. So not only do you have to worry about your supervisors who you're strictly reliable for, not only do you have to worry about your employees who you're responsible for, if you have reason to know that they're up to no some inappropriate behavior, but you also have to be responsible for your customers. It's your job to safeguard your employees under California law in all aspects of harassment and discrimination.
And the other thing people don't think about is you could be subject to harassment and discrimination for applicants. I mean, someone who's applying can allege a discrimination or a harassment complaint. Anybody that's in the zone of interest, your vendors, if your vendor's acting inappropriately and you know about it and you don't do anything to stop it, that can be an issue. So it's not just your employees and former employees, and it's your customers. If you have a consistent customer who's being abusive and it being improper, you need to stop it. Or your vendor who's coming in and being abusive, and then applicants. You can't discriminate based on a protected category for applicants either. So be wary. There are a lot of protected interests. And applicants, you've got to be cognizant that you can't ask them about their race, religion, national origin, gender, marital status, pregnancy. You can get in trouble for those things too. So be aware of that. I mean, this is a short ask the question, but be aware that, you know, what you want to do is get into the facts when you have an applicant about how they can perform the job. Don't get into their personal life. If they share something about personal life, um, just move on. They've shared it. You didn't ask for it. So just make sure. And you can't ask them about criminal background until after you have a pre employment condition. So be aware of the applicant issue. A good way to prevent this stuff, as well as knowing the law and knowing these issues, is it's important to have comprehensive anti harassment and anti discrimination policies. You should have a handbook or policies or both that says very specifically that the company prohibits any form of unlawful discrimination and lists all the protective activities. You should also make it clear in your policy that you have a policy that prohibits any kind of harassment, including both visual, touching, as well as words, that you don't allow derogatory comments, slurs, and epithets, unwelcome assaults, unwelcome touching. Give some examples. And you have a clear policy that retaliation when you file a complaint will not be tolerated. And that includes listing in the policy itself, if you have a complaint for any of these issues, that you can go to the Equal Opportunity Commission, you can go to the California Labor Commissioner's office, and you can go to the Civil Rights Department to file a complaint. And you put that in there, where their contact information. So it's important to have comprehensive written policies to prevent this. And you're facing this litigation isn't just about um, it's about money, and it can be significant money, and it's not just loss of income. It can be emotional distress. It can be liquidated damages. It can be attorney's fees. It can be the costs of litigating. So it's important to have things in writing. So from a standpoint and overview, John, what do you think is the most important takeaways and action items to do?
Absolutely. Don't self censor what you think is a harassment or discrimination complaint. If you receive a complaint, even if you think it's not severe or pervasive, it doesn't go to one of the numerous protected categories. Treat it the same. Document it. Don't rely on memory, and then investigate as appropriate and take appropriate action. The more serious it is, the more of an investigation that's required, the more of a remedial action that's required. Document your remedial action. Document your supporting evidence, whether that's security video, whether that's text messages, not just with you, but with your junior employees. And then make sure that you're training your people to recognize these issues. And as I like to say in one of our previous podcasts, not to be the last person with the secret, not to be the junior person with the secret, to make sure that they are passing that up so that you, your managers, your HR can take appropriate action.
And just a last point, the best defense isn't what you did, it's what you can prove you did. So documentation. So thanks all. We appreciate it.
Bye bye.